whether or not you will be in accord with what I'm putting to you. You accept that the decision to prosecute will remain extant, but insofar as the actual trial is concerned, you would want formal notice of when it is to proceed, and you would want the indictment to be reserved anew, and if that is so, all the processes that might follow upon then will then be open to both sides.
Yes.
Is that?
I accept that proposition, okay. Justice Nafsa, because that, of course, there are difficulties, but they will have to be addressed. You will recall that at the stage that this decision of Mshe was made not to continue the prosecution, at that stage, the matter before the Constitutional Court was at the stage where a written argument had to be presented. That is one of the factors that provided some time pressures in Mshe's decision.
Was that the Adams decision that went on appeal?
Yes. We had obtained leave from the Constitutional Court to come and argue the application for leave and the merits. If one looks at in 2009, you will see there's an affidavit from the NPA in the papers, and that deals with their opposition to that application for leave.
Are you talking about Mr. Deploy and others?
Yes. It is just confusing at times, because in 2007 the NPA were busy preparing the affidavit to oppose the appeal on the warrants. So when they talk about...
Are we going back and we're talking about the Farlam, Kluti and the other split?
That is correct. That was what was happening when Mr. Mshe took his original decision.
Mr. Kemp, I'm sorry, I don't mean to interrupt you, but I'm wondering where this excursus is going. I mean, I thought we had agreed if we inclined against the NPA, or NP, National Prosecuting Authority, and yourself on the legality of the decision to not continue the prosecution or to discontinue the prosecution. You accept that what then will remain instead will be the decision to prosecute, but that insofar as the progression of a trial or the initiation of a trial is concerned, you would want procedural aspects to be put in place so that you can then exercise whatever rights you have in relation to it.
Yes.
So far, so good. What does all this other stuff have to do with it?
Well, the following issue that I wish to raise with the court is that if, number one, the decision to discontinue the prosecution was improper because it had not been made under the appropriate legislative power. If that is so, it is our contention that what then must happen is that the representations have to be considered by the NPA, because then they have never done so properly.
I'm sorry, just let me understand this. The representations were made to Mr. Mshe to discontinue, right?
Yes.
You say if he's okay, so let me say this to you. I don't want to project for you what steps you will take later on, legal or otherwise. I don't think it's within our remit or our crystal ball to do so. Okay? All that we can do is make the decision, and once you accept the correctness, well, once what we've agreed upon then falls into place in terms of a decision of this court and an order that follows, the trial proceedings will begin. As to your rights in relation to that, those are not for us to enforce, those are not for us to select, those are up to you. So all of that is up to you. It's not something that we need to pronounce.
Yes, but Justice,
Are you giving us forewarning?
that may be one of the reasons, but
Mr.
it
Kemp,
seems...
let's just understand exactly what you're saying, because I think I know where you're going with this. The first thing is that if we find technically that the wrong section was used, and if that basis alone, which we set aside the decision, then as far as you're concerned, all the representations, all of those sorts of things continue. Correct. Right. If, however, we find, in addition to that, that there are other grounds, for example, that motive is completely irrelevant to the question of the service of the indictment. So it's not merely on a technical basis, it's on a substantively the decision is being set aside. Is your position exactly the same, or is it not the same?
Justice Kachalia, my answer to that is, if you find, if this court finds that Mr. Maché did not make a rational decision,
Yes.
then somebody has to make a rational decision on our representations.
So it matters not whether we find on a technical basis or the other. You just want to reserve your position in respect of further challenges.
Yes.
I don't know that we should become involved in that, Mr. Kemp. I mean, that's for you to do. It's for you and Mr. Ali to make the selection as to what you do. We will make decisions as to what the law is and nothing more.
So you effectively want no more than a procedural step to be taken to make sure that the prosecution continues.
What?
In a civil context, you'd want effectively a notice of set down. Here you'd want the summons, the indictment to be reserved, which would have a court date or something of that nature,
Yes.
so that the proceedings can then continue. At the moment, if there is nothing,
At the moment, there is nothing. That is our...
and what you want is a procedural step to be taken so that you would know where, your client rather, would know where he's got to be and what the defence team wants to do about the prosecution.
That is correct.
And that's all that you need.
Justice Leach, yes, but it seems to me that what my colleague was also trying to ask your guidance on, and you may be quite within your right to say...
Can we mark a brief, Mr. Kemp?
Justice Nafsa, you must, in that regard, discount it against whatever interest you have and get out of listening to this debate.
All right. So let's go. Where do you want to go?
What I am firstly saying, and I'll deal with the decision why, and I'll deal briefly with that, and you will understand the parameters of my agreement, of my argument as to why we say that the decision should not be set aside, but it would be very brief. But it seems to me what the NDPP wanted was also to know from this court what must happen if you decide that there was no proper consideration.
Mr. Kemp, let me cut you short. I'm sorry, but if you wish to pursue it, tell me. But it does seem to me that we're asked to adjudicate on one of a number of bases. We will make that adjudication.
Yeah.
We will also say what the consequences are of whatever the decision is. What anybody else does with it subsequently is not our business.
Very well, Justices. The point I simply wanted to make, and I'll make it and then move on, is very simply that the accused, as he then was, had the right to make representations, and he had the right for those representations to be probably considered.
Well, it's really, you're responding to my brother Kachalia, who said, does it matter on what basis?
Yes.
And you say, whatever happens is, if there isn't a proper decision in place, then a proper decision needs to be made, and our representation needs to be taken into account.
Yes.
That seems to be a position you want to reserve.
Yes.
Well, far be it from us to take that away from you.
Yeah.
But
That's not what we need to be concerned with.
Very well. Then I will address exactly what our submission is about the wrong section. Is the representations were made on the basis that the National Prosecuting Authority had the power to review or to change or to decide to discontinue the Michelle decision to
Well, so you're really making common cause with Mr. Epstein's supplementary heads.
And what I'm saying to the court...
Mr. Kemp, it's not a trick question. Are you making common cause with what Mr. Epstein put in his heads in terms of... Well,
Justice Nafsa, my submission is that as far as the accused is concerned, it is only up to him to put the representations before the NPA, and they have to deal with it. If as a, and is you will have noticed in our affidavit that was filed in this matter that we said, but how you came to these decisions, you seem to have very different versions at different times.
But that seems to be correct. I mean, it does seem to me to be correct, excepting for one thing. In their versions, at some stage, Mr. Mshe is part of the decision-making. At other stages, it's not. It's Mr. McCarthy.
Yes.
But Mr. Mshe is the decision-maker, is he not?
Justice Nafsa, we have always accepted that he at least agreed with the decision, at the very least. But how they deal with our representations and how they make sure that the right person under the right section deals with it, that is for the NPA to deal.
But if they did it wrongly, Mr. Kemp, and that's the issue, and that's what I'm putting to you, and I'm really putting to you the Liebenberg Constitutional Court principle. That's quite clear. You've got to know what power you're acting under. It's more than just, I made a typographical error. I'm sorry, I referred to section 176. What in fact it was 177, and in fact I used the power I had in terms of section 177. If they get it wrong, then the decision can be overturned, must be overturned.
I cannot argue with that proposition. Okay. If I got that wrong, from the third respondent's perspective, we obviously never really knew exactly how their decision-making took place.
I'm not blaming you for their wrongs, Mr. Kemp.
Yeah.
Mr. Kemp, if that being the case, is there any basis upon which your side would now wish to defend the decision, Mshe's decision? Is there any basis upon which you say that decision should remain, and then let us know?
Well, may I just make this submission, and it will serve as an answer, and I will then specific in terms answer your question. It was always the applicant Zuma's case that one could never look at that timing charge manipulation on its own. On its own, it doesn't seem to be so egregious. What the argument always was that you should look at all the other things that we have been raising relating to Brausmol, relating to the original decision of Mr. Nuka and Mr. McCarthy to prosecute in 2003, and we said you must look at all those things together.
I understand that, but leave that aside as the second point. In respect of the first part, I mean, I understand the submission that you made initially. And the initial was, well, we also took the position, well, it doesn't seem as if you knew what you were doing. The one, one hand didn't know what the other one was doing.
Yes.
Now, it seems to me that's consonant with the proposition I put to Mr. Epstein, that in fact, they used the wrong section. On their own version, they used the wrong section. Their attempt to distinguish it doesn't help because they're bound by the facts, muddled as they are in their affidavits. So before we get to the second part, which is really the part about whether it was rational and whether all of these other issues, and that doesn't take away your ability to deal with it a la the representations post this hearing. Can you defend technically the basis at which this decision was arrived at?
No, I'm not defending that.
So you can't defend that. So what we're at idem about is that in terms of the decision and the technically correct aspects, they erred.
I would accept that, Justice Nasser.
No, well, let's go a step further. In other words, they made an irrational decision.
Well, that is then correct, yes.
So your case is not that you want your cake and eat it. It's not that you support the decision, but if that decision is insupportable, then you want to have your representations that you were made dealt with. As I understand your position now, you accept that the decision was irrational and cannot stand, but you still want your representations, account to be taken of your representation.
Yes, and it has always been the case that you, and that is the case that we have always made, that you cannot look in regard to our representations to an isolated fact.
Okay.
Like,
yeah, but that's for the decision maker.
yes.
Well, could I just ask you this, Mr. Kemp, perhaps you just give me a second to ask Mr. Epstein to be on his feet. Just give me a second for Mr. Epstein to be on his feet. Mr. Epstein, you wanted to listen to whatever ingenious arguments Mr. Kemp may have come up with in respect of the validity of your decision.
Yes,
Before you took an instruction. Well, you've heard Mr. Kemp.
I have. He hasn't added anything which may help me. And while this was the exchange has taken place, I reread Liebenberg, and it's directly against me.
It's directly against.
Directly against.
All right.
We contend for that it's proper not to continue the prosecution, but if that hasn't been properly decided as yet, we cannot rely on that decision.
Sorry, let me just say this. If we set it aside and you get notice in respect of what happens prospectively, that I thought you accepted.
Yeah.
You wish to have in the subsequent process your representations to be considered.
Yes.
But then this whole question, I thought you also accepted that insofar as we're concerned now, the issue of judges transgressing into the territory of prosecutors does not arise.
Justice Nafsa, I understand that and I agree with that proposition generally. I do not, in this case, say it arises. What was the problem was that the judgment of a court below was read as if the next day...
As if they're ordering...
that the next day we appear in court and everything goes on as before.
Well, we've now decided that between us, I mean, whether or not, I mean, my brothers and sisters must tell you whether they have a different view. But I, for the moment, don't appear to find anything objectionable with, in principle, conceptually, if we were to say in the body of a judgment, if we inclined against the NPA, that the decision to discontinue gets set aside, that the logical consequence is that the decision to prosecute remains instead, but that in order to facilitate the progression of a trial and such remedies as may be, or such powers and remedies as may be available at the disposal of each party will then be at their disposal. We can't do anything other than that.
Yes.
And that what will be envisaged is that an indictment will be served anew as to when and as well as a date on which a trial will commence. Yes. Then you do what you must do, and Mr. Abrams will do what he must do.
Yes, because this court knows now that it's no secret what our stance is, what must happen. If our representations were not duly considered, they must be duly
Well, so you're in agreement that we set it aside and that we do what you say should follow in respect of the processes.
Yes.
May I just ask, because it's a bit, the one thing about your representations that are quite unclear to me. You made written representations, correct?
That is correct.
That Mr. Share rejected. That they'd made the decision regarding your written representations was that there's a strong case, we're going ahead with it. In addition, you made oral representations. Those oral representations, together with the tapes, seemed quite decisive. But the entire basis of your representations was that going back years now, there's been a political conspiracy against Mr. Zuma.
Yes, that is correct, and
that's the heart of it. Do I understand?
And that is certainly part of it, and what?
No, but it's a critical part of it. Correct?
Yes, it is.
So again, I'm a bit perplexed because that whole political conspiracy motive thesis was rejected by this court in 2009. So where are? Which irons are you keeping hot in the fire now?
Justice Kachalia, as I understand the 2009 decision of this court, the point was made that a motive, an improper motive, doesn't render a prosecution wrongful. And we say that if you really read that passage, it further says, well, and you can only work out even if a prosecution is wrongful after it has been done. Those words appear there. So what the court was referring to was like wrongful arrest, wrongful prosecution, etc. We say it is an entirely different issue when matters like permanent stay considerations or policy considerations affecting the prosecution by the NDPP moves him to decide not to continue prosecution. We say those are not similar concepts. They are different concepts. And we have made the point in our heads as well that the discretion to prosecute is not even the counterpart of a permanent stay. You don't have to persuade the NDPP that you have a cast iron permanent stay case for him to decide the game is not worth the candle in a particular...
Well, it's really the Maxwell line of cases, isn't it?
Yes.
But can I just come back to this? So I understand that you and Mr. Epstein now appear to be in agreement that the decision's got to be set aside. Do we need to engage in anything further beyond it once we make that decision and we have a formal judgment that deals with what can be said or can't be said? Do we need to engage beyond it?
No. Because the argument that I want to present, I must then put before the NDPP or not before a court.
And whether it's good or not, and whether or not you're bound by what Justice Haram said, that's an issue beyond argument.
Yes. Yes. We did try to take that on appeal, but obviously that appeal...
Sorry, just run that last part beyond?
We did try to take that on appeal, but that appeal was, of course, ceased as a result of this decision. Because there would be no practical effect on trying to...
Well, it's again something that we don't have to consider.
It's not something. I'm simply giving you the background to understand how certain things came about in this matter. If that is what the court finds, then you are quite right. You do not have to consider the merits of what we say. And the one point that we were putting forward in our heads is that if it comes to a rationality review, it is not correct that a party who's directly affected by that is bound by the version of a decision maker.
No. Well, In relation to what? Because in relation to this particular decision, we've agreed that it's bad and should be set aside.
Yes.
Why are you making these extra
Well,
submissions?
Justice Nafsa, we don't have to go there on the basis that you've put it to me.
Okay.
But that was why the third respondent...
Could I just put the following to you? Because I want to make sure that we are not at odds with each other. If we decided that because of what is effectively what the issues that arose in the supplementary heads by Mr. Epstein, that's wrong and that the law is as it is in Liebenberg, and we set it aside. Well, it would also go to rationality over and above. Do you accept that?
Right.
Over and above the fact that you can't use the wrong power, it would also be irrational. So
Yes.
we accept. So we club those two together. What the result is of that is that it gets set aside, and that's the end of the matter.
That is the end of it.
What do you say about cost then? Because you came to court seeking to protect the order, or to attack the order, and to have the order of the High Court set aside, and seeking an application being dismissed with costs, including the costs on 3 counsel. So what do you say about costs now? If you accept, having come to court to attempt to support the decision, you now concede the irrationality of the decision. Does cost not follow the event?
Yes, Justice Leach, save for the fact that we do point out that whether Section 1795D was applicable or another section was applicable was something always peculiarly within the NPA's knowledge. It depended on how they took the decisions and whose decision it was as to whether, as we know now, it was taken under the wrong section. That was not something that we could control. And the only submission we make about that is, it seems to us that the NDPP said, well, let me try and do it under 1795D because that allows for the greatest input and the less criticism.
Well, what would be wrong with us saying that the two of you are jointly and severally liable for the costs of the DA, and I don't know that they'll get the cost for the entire contingent, but that's a separate issue.
Well, Justice Nafsa, we can only say if we could defend the objective rationality of a decision, we may have been able to do that. I'm not suggesting to you that we spend 2 days in debate when the only implication of that is a cost order.
All right.
But in the light of everyone seeming to have want costs of 3 counsel, would you, if there is a cost order, a joint and several cost order, would it be include 3 counsel?
Justice Leach, it seems...
Or did only 2 of your juniors do any work?
Yeah. It seems to me that the Constitutional Court generally allows only in very exceptional cases the cost of more than 2 counsel.
Everybody seems to have thought this was a very exceptional case.
You know, Justice Leach, from the debate, it seems that a lot of people thought a lot of wrong things about this matter. But those are the submissions I wish to make.
Thank you. Mr. Rosenberg?